Welcome to today's session on data protection. So my name is Andrew Galley and I'm a partner in the information law team here at VWV. And so the purpose of today is just to sort of chat you through some recent developments in data protection law, but also look at some of the the key tricky areas that we've been advising GP practices on recently. So in terms of what we're going to cover today, I'm going to start off by looking at subject access requests. I'm then going to spend some time thinking about the new Data Protection and Digital Information Bill, which is set to reform data protection law. So just when everyone got used to GDPR, it's set to change again. And I'm then going to finish off by looking at some tips around data sharing and the sorts of things that you should be including in your contracts. But before we do that, though, I just want to very briefly just sort of remind ourselves of the data protection basics. So what do we mean by data protection law? So when we talk about data protection law, we really mean three things. First, you've got the UK GDPR, which contains most of the rules, most of the things that we all have to comply with. For example, the data protection principles, the requirements around information security, and also people's right in their data, so their right to make a subject access request, for example. The GDPR is supplemented by the Data Protection Act, and it's the Data Protection Act that contains most of the exemptions that will often sort of seek to rely on. For example, if you receive a subject access request and you think disclosure might cause harm, then the relevant exemptions can be found in the Data Protection Act. And then the third of the pillars are the privacy regulations, and these contain rules around setting of website cookies and also rules around electronic marketing. So perhaps really, I think for you guys, the focus should be on the GDPR and the Data Protection Act, with the privacy regulation sort of having less significance. So as I mentioned, things are set to change with the introduction of the Data Protection Reform Bill. The reason for the change is that there's a perception that data protection law is too inflexible, and it doesn't sort of and there's too much box ticking, particularly around sort of the requirements around policies and procedures. And so the intention is to make things a bit easier for organizations. It's perhaps the first data protection law ever that's sort of looking at sort of reducing the burden rather than increasing it. But it remains to be seen to what extent that objective will be achieved, because with any change, there's sort of inevitably a cost in sort of changing your policies and sort of making them compliant with the new rules. So jury's out on to what extent it will sort of achieve its objectives. So it's still early days. The reform bill has only just been published, and it will be subject to further changes. Having said that, I doubt it will change substantively. So the current draft is probably pretty much what it will look like when it becomes law. There's no sort of specific time frame, but we expect the new rules to come in for it to become law in May next year. Sorry, early next year. Okay, so just the final piece on this slide. This talk is really just about data protection, but I just want to sort of put that in sort of context of your wider duties. And just by way of reminder, in addition to data protection law, you've obviously got the common law duty of confidentiality that sort of contains rules around how you can sort of use and share patient information. There is a big overlap between data protection and the common law duty, but they're not quite the same thing. So when thinking about sort of data sharing, it's important to sort of have regard to that as well as the data protection principles. Okay, so as I mentioned, the first thing I want to talk about are subject access requests. And I think certainly based on the work I do for GP practices, I think this is probably the area that many sort of struggle with the most. And what I often find is that sort of practices will actually give people too much information, and the right isn't quite as extensive as, say, as patients or sort of staff making requests might think it is. So fundamentally, the right gives people a right to access a copy of their personal data, and it's very, very rare that a request is made in isolation. A request is usually made as part of a wider dispute or complaint. So what we often find is that a request might be made as part of an employee grievance, or a request might be made by a patient who's sort of making who's got a wider complaint about the practice, and they want to sort of bring data protection into it. And with that in mind, it's really important to take a strategic view at the outset. So be thinking about sort of how can we sort of respond to these things strategically, to sort of minimize the amount of work that you have to do. So, for example, one approach is to sort of be really transparent with people and sort of provide as much information as you sort of can in response to the request. But equally, sometimes it pays to sort of adopt quite a narrow view and sort of apply the exemptions vigorously, so as to withhold as much information as possible. One of the first things you should be thinking about is whether you should ask the requester for clarification. You are entitled to do this if you hold a lot of information about someone and it's not clear what they want. So let's say, for example, that you had an employee who's worked for you for 15 years and they make a SAR for, quotes, all of their personal data. You might hold a significant amount of information about that person, and so you're perfectly entitled to ask them what it is they're actually after. So do they want information about their particular incident, for example? Do they just want their HR file, and so on? If the requester comes back to you and says, no, I want absolutely everything you hold about me, you still got to carry out a reasonable search. But again, that doesn't extend to sort of looking under every single stone to see if you can find every single location that might conceivably hold disclosable personal data. You've got 1 month to respond, so you've got to provide the response within 1 calendar month. However, you are entitled to extend that by up to a further 2 months if the request is complex. And it's really up to you to decide whether the request is complex, but the sorts of factors that might make your request complex is if, for example, you need to take legal advice and you don't usually do that, or if it relates to a particularly tricky situation or sensitive data. For example, if you receive a request from a parent for their child's data and you've got concerns that disclosure might cause safeguarding concerns. You're also entitled to take account of your resources when deciding whether or not a request is complex. So if you're sort of a smaller practice, then arguably it's easier to claim the extension than if, say, you were sort of part of a large, well-resourced super partnership. As I mentioned, the obligation is to carry out a reasonable and proportionate search. And that doesn't mean sort of searching every single record on the off chance it contains disclosable personal data. So it's a reasonable search. So be thinking about the sorts of areas on your systems where personal data might be held. You can, of course, carry out keyword searches, but there's no legal obligation to do that. And what requesters sometimes do is they in their request they'll sort of ask you, they'll sort of list the keyword searches that they want you to carry out, and sometimes these are completely unreasonable. So if you get a SAR from, say, John Smith, Mrs. Smith might say, can you include Smith as one of your keyword searches? When clearly that would return a huge number of irrelevant results. So if keyword searches are offered, you are not under an obligation to actually carry out keyword searches. You've got to do what's reasonable. I often suggest a sort of a three-pronged approach. So when trying to locate personal data, think about the locations where the information will obviously be held. So if it's a staff member, for example, their HR file, speak to the individuals who might sort of have relevant information about them. And then as the third step, sort of think about the keyword searches, but but keep it proportionate. We had a search recently. We helped a client with a search recently where we did the searches at our end, and the searches returned over 100,000 pages of documents that contained keywords. And so our view was that that there was no requirement to sort of manually go through those 100,000 pages on the off chance they contained disclosable personal data. So keep it reasonable and proportionate. The other thing I would suggest you should do is just keep in mind the definition of personal data. So personal data is information that identifies someone either directly or indirectly and relates to them. So it's got to be about them, it's got to relate to them. And what that means is that the vast majority of the information you hold about someone, the vast majority of documents that might name someone probably don't contain their personal data, particularly where we're talking about staff. So if, for example, you have a member of staff who's prepared a report, that report is very likely to be their personal data because that's them acting in their professional capacity. It doesn't really relate to them. The only information about them in that report is their name and possibly their job title. And that information will be disclosed elsewhere in your response. So there's no need to provide a copy of that report. This means, for example, that it's very unusual for there to be personal data about a GP or a staff member contained in patient information. What might, although the starting point is that sort of records and information created by staff in the course of their duties aren't their personal data, it's possible that in limited circumstances it could become their personal data. If, for example, the document that they produce was used in connection with a complaint or with a capability process, because then it would be about them, because it is being used to make decisions about them personally. But for the most part, those sorts of information don't contain information that you would need to disclose in response to a subject access request. And there's a related point, which is this. The obligation under an SAR is to disclose the information rather than original documents. So it's perfectly lawful to extract the personal data from an email or from a document and put that into a table and disclose the table to the requester. And that's often the best approach, particularly if you're finding that you're making so many redactions to a document, there's nothing left in it. What we often find is a disclosure will sort of contain mostly redacted documents, but then where it's very difficult to sort of make redactions, then that information is sort of extracted into a separate table, and that table is provided in addition to the documents that were easy to redact. My other top tip is just make sure that you're sort of storing information in a way that makes it easy to search. So if you do sort of get a request, you're not sort of spending hundreds and hundreds of hours looking for information that should be at your fingertips. A starting point is that if you receive a subject access request, then you've got to provide the information that falls within the scope of the request. That is, however, subject to a number of exemptions from disclosure, and I've set out on the slide here some of the key ones, some of the ones that we find the most helpful in practice. So the first one I want to talk about is what we call the mixed personal data exemption. So what this says is that if information is both about the requester and also about a third party, then you don't have to provide the information unless either the third party has consented or it's reasonable to disclose in the absence of consent. And there is no legal obligation to seek consent, and sometimes doing so just wouldn't be appropriate. So in many cases, it's about balancing up the requester's rights to the information against the rights of the third parties. So let's say, for example, you had an allegation was made against somebody senior and there was an investigation, the subject or the allegation might try and make a sort of access request to obtain additional information. This argument can sometimes be used to sort of protect the identity of, say, junior members of staff who sort of raise concerns on a confidential basis. But it's less effective if we're sort of trying to protect people more senior. So it couldn't, for example, be used to sort of redact the names of your head of HR if they were sort of investigating, or if they were involved in their sort of in their HR capacity. The thing is this: there's also a slightly different rule for patient information. So if a patient makes an SAR, then this exemption can't be used in most cases to sort of to allow the practice to sort of redact the names of the health professionals who've sort of been involved in the care or treatment of that patient. So it's really there just to sort of stop healthcare professionals sort of hiding behind data protection when responding to SARs made by patients. So in terms of the other exemptions, we've got the negotiations exemption. So this applies where there are ongoing negotiations and disclosure would prejudice those negotiations. So again, taking a staff example, if you're currently negotiating the terms of a settlement agreement with somebody, there might be internal emails that sort of set out what the practice might be prepared to offer, or sort of a worst case, middle and best case scenario. It would clearly completely undermine your negotiating position if you sort of if the requester could get hold of that information by making an SAR. And so you don't have to provide information that would prejudice your negotiations. There's also excuse me. There's also a similar exemption for what we call management planning, and this is where disclosure might sort of prejudice the operation of your practice. It's often used, for example, if there's a restructure and people start sort of making SARs to find out if they're going to sort of be made redundant, and this exemption means you don't have to sort of share that information until the official announcement is made. There's also an exemption for legal professional privilege. So if you sort of get legal advice, or if there's ongoing litigation, then things can be exempt in that context as well. So you don't usually need to share personal data contained in legal advice. Just sort of going back to what I mentioned at the start of the section around strategy. As I mentioned, it's sort of a decision has to be made about whether you sort of adopt a really sort of broad approach and be really transparent, or whether you sort of want to sort of apply the exemptions in a really sort of vigorous way to sort of try and withhold as much as possible. And what you do will very much be informed by sort of the wider context and where the SAR is going and what you think the risks of disclosure might be. In terms of risks more broadly, if you get a SAR wrong, then the risks are very low. The ICO has only ever fined one organisation, as far as I'm aware, for getting an SAR wrong, and that was a GP practice that didn't make enough redactions before providing some information to a requester. And so what that sort of demonstrates is that first, it's really important to make sure that you redact appropriately. So apply the mixed data exemption appropriately, make sure that everything comes out. But actually, the risks of disclosing something by mistake are actually far greater than the risks of sort of taking a really sort of hawkish approach and sort of redacting lots of information. If you sort of disclose something and that turns out to be the wrong decision, then it's too late. You can't sort of put it back in the box. But if you've got sort of some information and you sort of see arguments for and against including it, often the best approach is just to withhold it, because the requester still has a remedy in that they can complain to the ICO, and the ICO may give their view on whether or not the information should have been shared. The ICO is often the first port of call for people if they're unhappy with how you've responded to their request. The ICO are, though, very, very under-resourced, as perhaps many of you will know, and they don't like getting involved in sort of the detail of an SAR complaint. And in my experience, they've never sort of they never seek to overturn or sort of seriously challenge a decision made by an organization to withhold information where there was sort of a safeguarding or risk of harm element to it. So can you ever sort of simply flatly refuse to respond to an SAR? And the answer is yes, where the request is either manifestly excessive or the request is manifestly unfounded. And essentially, these things sort of cover situations where the request is so unreasonable, or the requester is making the request just to sort of cause harassment and distress to your practice. So it's quite a high threshold, quite a high bar. Just to put this in context, I've only sort of advised a client twice in the past year to rely on that the request met the threshold, the manifestly excessive or unfounded threshold. And the first situation was where the requester, what they were doing was they were sort of publishing information about staff on the internet on their Facebook page, alongside extremely sort of hurtful and defamatory comments. So it seemed obvious that the individual was just making the SAR just to sort of gain extra information about people that he could then sort of publish on his Facebook page and make defamatory comments about. The second example was where somebody would make an SAR every month, and every month a new request would come in, and it just seemed that it was part of a sort of a wider strategy to sort of grind down the client and sort of make the client's life difficult. So it's quite a high threshold, but certainly something to keep in mind. I think particularly if you have a sort of a patient where you've got genuine concerns around sort of staff being abused, staff being harassed. If the patient makes an SAR, then I think you're on sort of good grounds in those sorts of circumstances to refuse the request. Next slide, please, Jess. So let's sort of start looking at some of the reforms under the data protection bill. So the manifestly excessive or unfounded exemption is going to be replaced with what are called vexatious or excessive requests. So you can now, so if once this becomes law, you'll be able to refuse an SAR or other information requests if it's vexatious or excessive. And to be honest, this seems pretty similar to the manifestly excessive or unfounded exemption, but it does look like it's sort of slightly more in favor of the controller. So perhaps the threshold has been lowered slightly before you can refuse the request. The bill's also quite helpful because it sort of sets out the sorts of circumstances in which you can claim the request is vexatious or excessive. For example, the nature of the request, the relationship with your organization, and to what extent it repeats or overlaps with previous requests. It also gives some examples of when a request might be vexatious. For example, where it's intended to cause distress, if it's not made in good faith, or if it's an abusive process. It'll be really interesting to see where the how the ICO and how the courts interpret this, because arguably any SAR made in the context of a claim or a dispute where the requester has a separate right to the information, e.g. as part of the grievance procedure, arguably any sort of any request made in those sorts of circumstances is an abusive process. So it'll be really interesting to sort of see sort of how far organizations can push this in terms of refusing requests. So I now want to sort of move on and look in a bit more detail about some of the changes being introduced by the Data Protection and Digital Information Bill. And the first thing I want to talk about concerns the Data Protection Officer role. So what's happening is the Data Protection Officer role is going to be scrapped. So when this becomes law, there will no longer be a requirement to appoint a DPO. And this was sort of one of these sort of the headline changes that was sort of mooted before the bill was published. And again, it sort of feeds into sort of reducing the burden for organizations on compliance. However, the DPO role is going to be replaced with a new position called the Senior Responsible Individual. So there will still need to be somebody who sort of has who's responsible for data protection compliance. And unlike the DPO, the SRI has got to be part of your senior management. And senior management is defined in the bill as being an individual who plays a significant role in the making of decisions about how the whole or a substantial part of its activities are to be managed or organized. So you have to think about whether your sort of your SRI meets that criteria and who can fulfill the SRI role. The DPO and SRI functions are similar. It's just that the bill sort of unpacks a bit more what those functions are. Now, on the face of it, this may seem like quite a substantial change, but crucially, the SRI can delegate his or her functions. So in practice, it may be that you sort of appoint somebody to be the SRI, and but in practice, it's the same people sort of responsible for data protection on a day-to-day basis. So things might not change because they've got that ability to delegate. In my view, that also extends to delegating to an outsourced DPO service. So if your DPO service is currently provided by another organization, you will still be able to keep that arrangement in place. It's just that they won't be referred to as the DPO. So we've got a question: can the SRI be the same person as the Caldecott Guardian? In my view, yes. It's still early days, but probably, so long as that doesn't sort of put them in a conflict position, which I suspect probably wouldn't, because they're both essentially sort of got responsibilities around patient confidentiality. So yes, my view is that yes, it can be the same person. So again, sort of in keeping with the government sort of more flexible, less box ticking approach, some of the requirements around data protection policies are being tweaked. So I'm sure many of you will be familiar with data protection impact assessments. These are going to be replaced with something called an assessment of high risk processing, which doesn't quite sort of roll off the tongue quite as easily as a DPIA, but never mind. So this is going to be quite similar to a DPIA, but there isn't quite the same requirement to go into the same level of detail. So for example, the GDPR says if you're carrying out a DPIA, you've got to sort of have a, quotes, systematic description of the processing activities, which is why you see sort of DPIAs running to sort of tens of pages. That's been replaced with an obligation to sort of to have a summary of the processing activities. So it should make DPIAs or assessments a bit less burdensome, so they won't quite need to be as lengthy. So that should make things a bit easier. If you, in my view, you won't need to sort of rewrite all your DPIAs. So if you've done a DPIA, that will also count as an assessment of high risk processing. So I'm not suggesting that you need to sort of rewrite everything to make it shorter, but certainly I would suggest you sort of adopt the new approach once the once the new rules come in. The requirement to carry out an Article 30, a record of processing, has also been shortened. So currently you've got to have what's called an Article 30 record, or a record of processing, which is an extremely lengthy document. It's not one the ICO are particularly concerned about. No one ever looks at them, so that obligation is sort of being watered down as well. You still need to keep records of your processing activities and your compliance, but there isn't quite the same requirement. For example, under the current requirements, you've got to in your record, you've got to sort of list every single type of personal data that you process, which is, quite an ask. Under the new requirements, you only have to sort of list special categories of personal data and information about offences. So, for example, information about health. So, it on the face of it, it'll make things a bit easier, but to what extent it'll make a difference in practice remains to be seen. A couple more questions. Does the SRI replace the need to have a SIRO? No, it won't. They're two sort of separate roles. Another question, will it mean we won't have to do anything if it is low risk? I wasn't quite sure which bit that related to, Kate. If you could clarify that, I'd be happy to answer that. Okay, so there's also so currently the legislation is silent on how to manage complaints, and that's changing with the introduction of some rules around complaint handling. And what's really underpinning this is that the ICO are sort of sick and tired of getting sort of inundated with what it sees as complaints that don't really sort of have any sort of particular merit to them. So first, there's going to be an obligation on organisations to facilitate complaints, which in practice will mean having a complaint form that complainants will need to complete. And you've got to acknowledge the complaint within 30 days and investigate and respond without undue delay. There's possibly going to be an obligation to tell the ICO how many complaints you're going to get, or rather you've had, but that's still sort of being that obligation still being sort of finalised. The ICO can refuse to deal with complaints if it's vexatious or excessive, or if the controller hasn't finished investigating and 45 days have not passed. So it just gives the ICO a bit of breathing space as well. So I just want to finish off this section by just sort of expanding slightly on complaints and how you should approach them, because I mentioned SARs are probably the thing that we advise GP practices on the most. I would say in second place, you've got complaint handling. So you've got a patient who's unhappy with how you've handled their personal data, for example. And I think in terms of top tips, I think it's just really important to make sure that staff are trained on sort of compliance, trained on managing complaints, and that's sort of backed up with the appropriate policies and procedures. Where I see things going wrong is sort of where a practice might sort of get sucked into a sort of a sort of dialogue with the complainant that just goes on forever. So sometimes sort of people try and be helpful, might sort of provide detailed responses to the complainant on the data protection issues, and often that just leads to more complaints, more questions, and it just goes on forever and ever and ever, and it sort of becomes this sort of huge drain on everyone's resources and time. I think there's often something to be said for sort of setting out your position once, and that's it, and then just sort of keep referring the complainant back to your sort of one letter that sort of sets out your position. And there's no harm in sort of, if you're sort of confident that you've done everything you can, there's no harm in referring the complainant to the ICO and making it their problem. Because if the ICO can see that you've sort of dealt with the complaint, everything's okay, then make it the ICO's problem. They are unlikely to sort of take action. If you do invite the complainant to go to the ICO, it's just important to make sure that you ask the complainant to send the ICO a copy of your sort of of your side of events as well, because we sometimes see people sort of present a very, very one-sided case to the ICO. Even go as far as to sort of copy and paste sort of sections from what the practice might have said to sort of misrepresent things. And if you do get in touch, if guys do get in touch, sometimes it's, you can just sort of deal with it just by sort of giving the case officer a call and just explaining your side of things. The ICO are as under-resourced as everyone else, and they want to get it off their desk as quickly as everyone else. The other top tip I have is, I suppose, is just around transparency. Is quite often a complaint might include a statement such as you didn't have a right to share this information with person X or with this other party. Well, if you make sure that your privacy notice is sort of comprehensive and covers up all your sort of sharing, all the ways you use personal data, sometimes it's just a question of referring the complainant to where it's covered in your privacy notice, and that can often address the issue. Okay. So I'm just having a look at any more questions. Okay, so I just want to finish off just by talking about data sharing, and in particular what sort of we should be thinking about from a data protection compliance perspective. So when you share personal data with another organization, you're either going to be one of three things: either a controller, a joint controller, or there's going to be a controller processor relationship. And it's really important just to be clear which of the three you are at the start, because the obligations are completely different depending on which of those three categories the sharing falls into. As I'm sure many of you will know, a controller is the entity that sort of makes the key decisions about personal data, so it decides for what purposes it's used, with whom it's shared, and so on. And a processor is somebody who sort of simply processes personal data on the instructions of the controller, and so they've got no discretion to use the data, and they certainly can't use the data for their own purposes. They're simply using the data to provide a service to the practice. Now, in the vast majority of cases, you'll obviously be the controller of the data. So if you're sharing data with other healthcare professionals, you'll both be controllers. But if you use service providers, so let's say you IT providers, if you sort of use an online system to sort of to hold staff data or patient data, then they're going to be a data processor. And when you use a data processor, you need to make sure that there is a written contract in place that contains the wording set out in Article 28 of the UK GDPR. And so the legislation is very, very prescriptive about what must be included in a contract between a controller and a processor. So make sure that wording is in place. As a second step, you've got to carry out due diligence on the contractor to make sure that they're actually complying in practice. So it's not sufficient just to sort of have the contract and then sort of forget about it. You need to make sure that they're compliant. So are they sort of certified to relevant information security standards? Is the data encrypted to a suitable standard, both in sort of transit and at rest? So it's important to sort of to make sure that you sort of you involve sort of colleagues with an IT bent when looking at these sorts of things as well, because some of the issues can get quite technical. And then the third thing is this: is if the data is leaving the UK, then there's an extra step for compliance. Excuse me. So if the data is going to a country, so let's say that you sort of use a service provider that stores data on servers based in France. If the data is going to the EU countries or certain other countries, then you don't really need to do anything else because those countries have a finding of adequacy from the UK government that that their data protection laws are adequate. But if the data is going elsewhere, for example, if it's going to I don't know, America or Brazil or India, then you need to sort of do an extra step for compliance. And that will usually involve making sure that your contract with the provider contains the standard clauses for international transfers. So these are sort of government-approved clauses that you need to include in contracts to make the transfer lawful. Now, these have been referred to as the SCCs, standard contractual clauses, but they're being in the process of being replaced by new clauses prepared by the ICO called the International Data Transfer Agreement, or IDTA. So as from 23rd of September, any new contracts that have a international data transfer element must be on the IDTA. For existing contracts, you have a grace period of until March 2024 to switch from the SCCs to the IDTA. But it's just something to keep in mind. Sometimes whether or not someone's a controller or a processor can be a bit confusing. And we'll sometimes see contracts where the third party is both. So let's say, for example, that you outsourced your HR provision to someone else, where the provider is sort of helping out with sort of things like grievances, disciplinaries, occupational health referrals, then there'll probably be a data controller because they're using their expertise to make decisions or to help you make decisions about your employees. But if their services also include running payroll, then they're going to be a data processor for the payroll services. So sometimes we'll see contracts that have both a controller and a processor element to them. Okay, so that was everything I wanted to cover. I'll just see if we've got any more questions. So we've finished a few minutes early. Okay, so we've got a question. The question is, would data storage on a server based in the USA used by a UK contractor be classified as an international transfer? The answer is yes, it would. Yes, it would, because the data is going from the UK to the USA. Now, in the situation you described, Kevin, where you sort of you share your data with a contractor who then themselves sort of transfers it to the USA, it's not always clear whether the obligation is on the GP practice or the contractor to sort of make sure it's compliant. But in practice, I would just make sure that the contract provides that it's got to be done in a compliant way, and I'd also suggest you sort of unpack a bit more sort of what they've got to do in practice. Following a sort of a judgment, a European court judgment, whilst we were still subject to EU rules, you've also got to risk assess any international transfer. And so I'd just be sort of talking to the contractor about sort of what the risks are around the transfer, and just sort of making sure that you're sort of comfortable with the security measures in place. Rather annoyingly, the ICO have been promising guidance on the risk assessment process for over a year, and it hasn't come out yet. So everyone's in a bit of limbo about what you actually need to do with international transfers. But yeah, it's certainly, to answer your question, it would definitely be an international transfer. So we need to be thinking about data protection compliance there. So I had a question. We get asked to pass survey links for PCN by text to our patients. Are these exempt from the privacy rules? The answer is no. So you're still going to be thinking about data protection compliance the same way you would for any other sort of processing. Because you're sort of processing personal data through sort of through texting patients. So it's important just to make sure that these sorts of things are covered in your privacy notices, so that sort of patients understand the circumstances in which they will be contacted.